Hi, I'm Alan Bloom, and I'd like to provide a brief history of special education. The history of special education really needs to begin with a conversation about the 14th Amendment, which came about in 1868. If you'll take a moment and you look at the 14th Amendment here, you'll notice that the word education is not there. But the Supreme Court has interpreted the concept or entitlement of education to exist within the language of the 14th Amendment. The concept that is there is property. Education is viewed as a property concept. What does that have to do with special education? When we are thinking about determining eligibility, writing an IEP, determining services for a student, we are thinking that we may have to adjust or alter that child's educational property in a way that we wouldn't be altering education for a student who's not going into special education. So we have to return to that property concept. So the 14th Amendment is important because it led to some other cases going forward. In 1896, we have the Plessy versus Ferguson case. Now, Plessy versus Ferguson does not have anything to do with education. It was a case that originated in 1892 as a challenge to Louisiana's Separate Car Act. What that did in Louisiana, it allowed and required that railroads operate separate but equal accommodations for white and African American passengers and prohibited passengers from entering accommodations other than those to which they had been assigned based on race. The Supreme Court ruled that separate but equal was deemed to be constitutional. The thing about Plessy, though, is even though Plessy was narrowly about train travel in Louisiana, it actually provided constitutional sanction for separate but equal in other areas, such as hotels, motels, transportation, restaurants, and schools. The impact of this is that now students with disabilities could be excluded from public schools, provided that the facilities were considered to be separate but equal. In the early 20th century, many children with disabilities were placed in institution or denied education outright. The focus was on isolation and exclusion rather than education or inclusion. Fast forward to 1954, Brown versus Board of Education. In the Brown versus Board of Education, the concept of separate but equal was revisited from the Plessy case and applied to education. Now, this was a unanimous ruling by the Supreme Court. It overturned the separate but equal concept from Plessy versus Ferguson. The Supreme Court, in a historic ruling, wrote that in the field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal. The court ruled that the plaintiffs were deprived of equal protection of the laws guaranteed by the 14th Amendment. In 1955, the Supreme Court had to step in again. It's referred to as Brown 2, because in 1955, schools had been slow about implementing the ruling from 1954. So in May 1955, the Supreme Court issued their desegregation implementation guidelines, which were known as Brown 2. Schools were required to implement the principles of the Brown decision. And in very clear language, the Supreme Court identified that localities must act promptly on the new principles and move toward full compliance with all deliberate speed. Even so, schools still drag their feet in terms of desegregation. From our history lessons, we know about federal troops coming into Central High School in Little Rock, Arkansas. In 1960, federal marshals escorted Ruby Bridges to school in New Orleans. In 1974, we had the desegregation busing riots in Massachusetts. So schools were not moving forward with all deliberate speed. You can see that in the history from 1959 even up to 1974. How did the Brown ruling affect students in special education? Well, there was little impact on special education. There were still institutional programs. There was minimal comprehensive programming. Really, there were no federal or state laws or requirements for the implementation of special education. But there became increased pressure to respond to special education needs. That really was an outgrowth of the civil rights movement. In 1965, we have the Elementary and Secondary Education Act, referred to as ESEA. The 1965 law was a plan for addressing inequality for economically underprivileged children. So there was federal funding to improve education of categories of students, including students with disabilities. But the important thing about the 1965 law is that it was grant-based and it was not a permanent piece of legislation. 1966, we have Title VI, which was added to the Elementary and Secondary Education Act. What this did is added limited funding for students with disabilities. Again, time limited, and it was not permanent funding. In 1971, we have a federal district court ruling, Wyatt versus Stickney, that came out of Alabama. The ruling in this case was that students in state-run institutions have the right to treatment. And what this ruling did is established minimal treatment standards. What it did is identify the need for individualized treatment plans, that there needed to be qualified staff in numbers sufficient to administer the adequate treatment, and provision of humane, psychological, and least restrictive environment provision of services for students in institutions. This really became the basis for what we later know as the LRE, or least restrictive environment concept, that came about in special education law later on. In 1972, we have a Supreme Court ruling, Mills versus Board of Education, District of Columbia. In this case, students with disabilities in the District of Columbia had been denied public education based on the argument by the Board of Education that the cost was too high. They didn't have the money to educate students with disabilities. The Supreme Court ruled that students with disabilities are entitled to an education. This was a class action lawsuit, and the court ruled that students with disabilities were unjustly expelled from school without being given due process. So this ruling guaranteed the right of students with any disability to public education, regardless of the cost to the school system. It led to a conversation about establishing a comprehensive federal legislation protecting children with disabilities' rights to a free public education. This later became the basis of the concept of free appropriate public education and those requirements that came out in later legislation. We also have another Supreme Court ruling. This is called Pennsylvania Association of Retarded Citizens, PARC, versus Commonwealth of Pennsylvania. In this case, the court ruled that the state could not deny an individual's right to equal access to education based on an intellectual or developmental disability. In this case, the Commonwealth of Pennsylvania had established minimum requirements for entry into public education and ruled that because these individuals had not met that minimum threshold, that they were relieved of their obligation to provide education to those students. In this case, there were 14 families who came together. They were families of individuals with intellectual impairments. These children had been denied public education based on their disability. These families challenged state laws that permitted schools to deny education to children who did not reach the mental age of 5, or the average intelligence of people aged 5 by the time they began first grade. This was one of the first cases to establish that people born with an intellectual disability should have the same access to public education as the rest of the population. 1972 was a busy year in the field of special education because in 1972, Massachusetts became the first state in the nation to have a special ed law. At that time, it was called Chapter 766. Massachusetts became the first state in the nation to have a law protecting the rights of students with disabilities to public education. Fast forward to 2001, this law that we used to call Chapter 766 is now referred to as 603 CMR 28, or shortly referred to as the Special Education Regulations. 1973, at the federal level, we have some more forward movement. We have the Vocational Rehabilitation Act of 1973. This was a federal guarantee to protect against discrimination of individuals with disabilities. It targeted agencies that were in receipt of federal dollars. So if an agency received any federal dollars, they were now linked to the Vocational Rehabilitation Act of 1973. We also know this as Section 504. That's the shorthand name for this. Under the Section 504 law, they've provided a definition of what is a disability under the umbrella of that 504 law. There are 3 prongs to determine whether an individual has a disability. Does the person have a mental or physical impairment that significantly impacts one or more of major life activities, has a record of that impairment, or is regarded as having a disability? So this was the first permanent piece of legislation guaranteeing or protecting against discrimination at the federal level. In 1974, we have Family Education Rights and Privacy Act, also known as FERPA. What FERPA did is governs access to educational records and reports. Like 504, it applies to educational agencies receiving federal funds. And in this law, it guaranteed that parents have the right to access their child's educational record and reports, and students have that right upon reaching age of 18. This FERPA law is really known for protecting privacy and confidentiality of educational records for students. 1975, we have Goss versus Lopez. This came out of Ohio. In the Goss versus Lopez ruling, there were 9 high school students who were suspended without having a hearing. In this case, the students claimed that their suspension violated the due process rights under the 14th Amendment. The court held that the state must recognize the students' legitimate entitlement to public education and construe it as a property interest protected under the Due Process Clause. This brings us back to that 14th Amendment that I started with earlier in this presentation. Now we get to 1975. Now remember, Massachusetts was the first state in the nation to pass laws and regulations guaranteeing the right to public education to students with disabilities. We fast forward to 1975, and Congress now catches up with Massachusetts by passing the first federal legislation guaranteeing and protecting the rights of individuals with disabilities to public education. The name of this law is the Education of All Handicapped Children Act, EAHCA. It's also known by its number, PL 94142. So in 1975, we have the first permanent federal legislation protecting the rights of students with disabilities to public education. It's really known for having 6 guiding principles. And the 6 guiding principles are the guarantee for a student to have an individualized education program, least restrictive environment, which we had talked about earlier, free appropriate public education, which I had talked about earlier, due process, making sure and guaranteeing those procedural safeguards to students, guaranteeing the right of parents and students to participate in the process, and guaranteeing that appropriate evaluations will be done for students. So those are the 6 guiding principles for which we know PL 94142. Now we go to 1982, 7 years after the passage of the EAHCA. And one of the concepts of that 1975 legislation was free appropriate public education. Schools had been wondering, what do we do? What is the concept of FAPE? And so in 1982, we have the Board of Education of Hendrick Hudson Central School District versus Rowley. The Board of Education of Hendrick Hudson Central School District had refused to provide a sign language interpreter to Amy Rowley. Now, Amy had developed exceptional lip reading skills. She had minimal residual hearing, and this was really a testament to her resilience and determination. But in this case, the school administrators and a sign language interpreter had determined that Amy could succeed in school without an interpreter. But the parents sued, claiming violation of the Free Appropriate Public Education Clause of the Education of All Handicapped Children Act of 1975. The Supreme Court ruled that that act of 1975 did not require a school to provide a sign language interpreter to a deaf student when she otherwise receives personalized instruction and an adequate education. School administrators are allowed to determine what is needed to meet a handicapped student's individual needs. In this case, they held that FAPE is a floor, a minimal floor when determining student progress. It's important to remember this is a minimum standard. I'm going to return to that in a later court ruling further on in this presentation. In 1985, we have another Supreme Court ruling that came out of Burlington, Massachusetts. Burlington School Committee versus Massachusetts Department of Education. In this case, there was a student, Michael Panico, who was considered handicapped, I'm using quotes there, handicapped, under the meaning of the 1975 Act. Michael continued to have poor performance, and Burlington was unable to meet his needs at Memorial School. So what happened is there needed to be changes to his IEP, and Burlington presented to the Panico family an IEP recommending that Michael be placed in another school in Burlington, the Pine Glen School. In the meantime, the Panicos met with specialists at Massachusetts General Hospital who recommended Michael's needs might be best served and best met at the Carroll School in Lincoln, Massachusetts. The Panicos enrolled Michael at the Carroll School at their own expense. They came back to Burlington looking for reimbursement for that placement. In their ruling, the Supreme Court held that lower courts have the authority to order school districts to reimburse parents for private school tuition, even if those parents act unilaterally. This was based on the determination that if that placement was indeed appropriate and necessary to meet a child's needs, the parents can be reimbursed for that even without the consent of the local school district. In 1986, the EAHCA was amended. We were amending that original 1975 legislation. What happened in this amendment was that it extended the protections and services of the Act to children aged 3 to 5, and it also introduced early intervention or EI services. Fast forward to 1990, EAHCA gets amended again. What they did was they changed the name of the law. Rather than having it called Education of All Handicapped Children Act, we changed the name to the Individuals with Disabilities Education Act, or what we know today as IDEA. 2 additional categories were added to the disability list from the original piece of legislation. What was added in 1990 was traumatic brain injury and autism. In addition, what happened in 1990 is that it mandated individual transition plans, or ITPs, for students, and they must be developed to help students transition from school to post-secondary life. Another piece of legislation that occurred in 1990 was the Americans with Disabilities Act, ADA. What this did was extended the Section 504 concepts from institutions receiving federal dollars and extended that concept into the private sector. So this became a broader civil rights piece of legislation prohibiting disability discrimination in all areas of public life. In 1997, in what we now know as IDEA, we have an amendment to the IDEA legislation. In this case, the amendment emphasized the importance of access to general curriculum for all students. Also, states were allowed to expand the concept or the definition of developmental delay to include students up to the age of 9. In addition, the 1997 amendment required parents to attempt to resolve disputes with school districts and local education agencies through the mediation process. In 2004, IDEA was further amended. One of the amendments to this piece of legislation was around early intervention services. Early intervention services were now inclusive for children not currently identified as needing special education, but who might need additional academic or behavioral support to succeed in a general education environment. It added greater accountability for improved educational outcomes for all students, and it raised the standards for instructors who teach special education classes. Early 2000s, we have what was then called No Child Left Behind, NCLB. NCLB focused on accountability and standardized testing, and this impacted special education by mandating student participation in state and district-wide assessments. Fast forward to 2015. We now have a piece of legislation called Every Child Succeeds Act. It replaced NCLB. It did give states a little more flexibility while maintaining the commitment to hold schools accountable for all students. requires high academic standards for all students, expanded access to high-quality preschool, and introduced the concept of access for English language learners. In 2017, we have another Supreme Court ruling, Andrew F. versus Douglas County School District. In this case, the Supreme Court revisited the concept of free appropriate public education from the Rowley case. The concept of free appropriate public education was considered a minimum floor. In this ruling in 2017, the Supreme Court determined that to meet its substantive obligation under the IDEA regulations, a school must offer an IEP that's reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. The court also emphasized, and this is very important, every child should have the chance to meet challenging objectives. The court soundly rejected the belief that just some benefit is enough. It raised the bar of expectation of free appropriate public education. Why does this matter? Why is it important to know the history of special education? Because I think this knowledge of the history of special education provides historical context to some of our current practices. It does provide insight into the progress that we have made over the past 100 years or so and the ongoing challenges that we face in the world of special education. Ideally, it equips individuals with the knowledge to advocate for students and their needs. It offers perspective to legal and ethical issues, sheds light on challenging attitudes that have been in place regarding students and individuals with disabilities, and hopefully prevents regression to practices of the past. I hope this was helpful and informative to you.